Good morning, everyone. Welcome to today's hearing. Today we're going to continue hearing evidence from Dr. David Crowder. So would you ask Mr. Crowder to come back in, please? Good morning, Dr. Crowder.
Morning.
All right, ready to carry on?
Yes.
Thank you very much. Yes, Ms. Grange.
Yes, thank you. Yes, good morning, Dr. Crowder.
Good morning.
So when we broke off yesterday, we were part way through discussing your work investigating the Lakanal House fire that had occurred in July 2009. Can we turn up a document BRE 405878 and look at page 195? Now, this is the text of the BRE's FOSI report. Is that Fires of Special Interest?
Yes.
Report into Lakanal House, dated the 3rd of July 2009. Now, this was appended to one of your investigation reports for the MPS, which is why it's here as an appendix.
Yes.
You see that?
Correct.
Now, is it right that this was the report that was prepared for the department in line with the objectives that we looked at yesterday in your second witness statement, i.e. to advise the department on whether there was a problem with the regulations and guidance or whether there had been non-compliance with the regulations and guidance? Is that correct?
Yes, correct.
Yeah. Now, if we look about halfway down the page, under address of fire, there's a bold heading, address of fire, for Lakanal House. We can see just below that, it says BRE Fire and Security Investigators, and you are there as the first name alongside Mr. Shipp, Miss Cullinan and Mr. Chitty, yes?
Yes.
Now, in your second witness statement, we'll come on to that. You give a date for the submission of this report to the department as the 10th of August 2009. Is that correct?
Yes.
And here we can see, underneath where we were just reading, under report completed, there are two dates given. One is the 16th of July 2009 and one is the 10th of August 2009. Now, you tell us in your second witness statement for the transcript, that's paragraph 78 on page 22, that you do believe that this report was first sent to Brian Martin on the 10th of August 2009. Is that right?
Sorry.
Sorry. You tell us in your second witness statement that you believe it was first sent to him, but then actually in your third witness statement, you explain that at paragraph 91, page 24, that you submitted an initial report to Brian Martin on the 16th of July 2009 and a final version on the 10th of August 2009. Is that correct?
Yes, that sounds correct. Yes.
Thank you.
I corrected in my third statement.
So it's as set out in your third witness statement?
Yes.
Yes, thank you. Now, before this final report was submitted to Brian Martin on the 10th of August 2009, can you help us? What information had been given to the department about the possible causes of this fire, in particular the external fire spread?
I'm sure we talked in broad terms around the performance of the cladding. I don't recall it being a huge concern at this time, and that was based on what's the word I'm looking for? The accounts from the firefighters. The firefighters that attended the building obviously had noted the external fire spread. The initial concern had been that an arsonist was making their way around the building and setting fires in different parts of the building, hence the pattern of fires that had emerged. But they hadn't expressed a particular concern about the speed of the external fire spread, merely that it had taken place. We flagged up that it had occurred, that downward fire spread was a very unusual thing to have occurred, that it's not something that had been encountered commonly prior to Lakanal or at all, I don't think. Martin Shipp wasn't aware of previous instances of this having taken place, and that it needed further consideration.
Right, and who did you flag that all up with?
Brian Martin at the department.
Right, I see. And had any testing on, for example, samples of the window panels taken place by this time, so by the end of July 2009?
No.
No. Now, if we go on within this report to page 196, and then in the first paragraph, fifth line down, it's identified. It says, if you look on the right-hand side, about 5 lines down from the top, it says, on odd floors, the external wall to each bay consists of a full-height painted aluminium window frame assembly with layered polymeric panels forming the lower halves of these sets. Do you see that?
Yes.
Now, are those the darker coloured blue-green window panels which we looked at in the photograph yesterday?
They incorporate those darker green panels, but it's a reference to the whole wall. But yes.
I see. So you're saying on odd floors, it consists of a full-height painted aluminium window with layered polymeric panels forming the lower halves of these sets. So you're not just referring specifically to the window panels there, are you referring to the balcony panels as well?
No, sorry. So the sentence as a whole is referring to the full story height wall assembly,
Yeah.
aluminium frame, glazing in the top 2/3, and
Yeah.
then at the end, your reference to, the reference in here to the layered polymeric panels. Yes, agreed. That's the dark green.
Yeah.
It's in the lower
Yeah.
third of those.
Great. And then further down on page 196, at the end of the fourth line up from the bottom of that paragraph, we can see it says, it's the top paragraph, but I'm reading on the last 4 lines. It says, on even floors, a blockwork half wall with door and window set leaves room for a narrow balcony on each side of the building, providing additional means of escape to the main stairwell. This is described in more detail later. Balconies have steel guardrails and polymeric panels fitted to them. So those are the balcony panels, yes, the lighter green panels we saw on the building.
Yes, they are.
Yeah. Now, what's meant in this report by the word polymeric? How did you think that would be understood by the readers?
That we had been able to ascertain that there was some form of plastic, but we hadn't fully established the composition at that time. Simply
No.
that they were not metal, for instance, they
Yeah.
were timber.
Yeah. And would it be right to say that a polymeric or plastic material would generally be a combustible material?
Yes.
So within this short space of time then, you and the Investigation of Real Fires project team, you have identified polymeric materials on the external wall of Lacknell House.
Yes.
Yeah. And then if we go down to page 202 of this report and look in the third paragraph down on this page, we can see it says this: falling, burning debris from flats 79 and 65, most probably from both the window facade assemblies and the contents of flat 79, ignited materials in flats 37 and 53, located on the 5th and 7th floors respectively. It has not been possible to determine which source of falling debris was responsible for each flat that was ignited. Footage from Channel 4 confirmed reports that these 2 flats happened to have windows open. These windows appear to be open in such a way as will enable them to collect falling debris into the flat. And then you say flat 37 appeared to become involved shortly before flat 53. So we have that description there. And then on page 203, if we could go to that, about halfway down the page, there's the first heading in bold is potential implications for building regulations. Do you have that?
Yes.
And it says underneath that, the following issues are of note with respect to building regulations and approved document B. And then third paragraph from the bottom of that page, we can see a heading external fire spread. And it says external fire spread, yes. Fire initially spread up externally from flat of origin. Fire spread down due to burning material falling. Wind may also have been significant in blowing the fire through the corridor. So we've got both upward and downward external fire spread being reported here. Yes?
Yes.
But there's no further commentary provided in this report, is there, on the possible reasons for the observed external fire spread, either up or down, is there?
No. This report was as much as could be prepared from the initial investigation.
Yes.
As has been exhibited with one of my witness statements, apologies, I forget which, the department ultimately made the decision to discontinue the investigation. I
Yes.
would have liked to have continued.
Well, I'm just going to come to that. What I'm seeking to do at this stage is ascertain what you had worked out at this point.
Yes.
And then I'm coming to the fact that we can see the department shuts down the investigation.
Yes.
And I'm going to ask you about that, so I'll come to that in a moment. But let's just focus on where you'd got to in this report. So no specific information is given in this report on the specific makeup of the external wall products, is it? Other than
no.
the fact we've got polymeric, i.e. a plastic panel, that's all we've got, yes?
Agreed, yes.
And so no information is given about the compliance or otherwise of the materials used in the external wall, either with the building regulations or with the guidance contained in ADB.
Agreed.
Yeah. And I think, as you've just pointed out, it's fair to say that those matters are omitted. Is this right? Because there was simply not enough information by the 10th of August 2009 to provide that detail.
Agreed.
And you say in your third witness statement, you describe this report as having presented itself as nothing more than an incomplete investigation. Is that right?
That is correct, yes.
Yeah, that's at paragraph 153 of your third statement. Now, did the observations that you made in this report and your understanding at the time, did that raise concerns for you about the downward fire spread? Were you concerned about that at this point?
I certainly wanted to better understand what had happened and why. And I did, I forget whether it was, although I could probably find out from when photographs were taken, I did try and figure out what the particular items were that were responsible for the flats on the lower floors having been ignited, though it ultimately wasn't possible to determine from the physical evidence. But it was certainly an area of interest that I thought warranted further work.
Yeah. And were you also interested in understanding how the vertical fire spread had happened in terms of going up to flat 79 and the mechanism for that?
I was, although that was a more traditional direction of fire spread, so there was less of an intrigue, I suppose, for want of a better word, in terms of why that had occurred. It was just, it was, I wanted to understand more about the particular timing of that, whereas with the downward fire spread, it was to develop a more fundamental understanding of what had occurred in the first place, given it wasn't a phenomenon that was commonplace at that time.
Yeah, yeah. And when you talk about the timing, did you have any idea at this early stage how quickly the fire had spread upward to flat 79?
No, as I said, we had asked the attending firefighters for some sort of view as to how they felt the incident had progressed in terms of speed and so on, which is always difficult because fires are obviously high-stress events and people's timings can differ in terms of their views. But they hadn't expressed a particular concern, as I said, about timing, but I did still want to understand what the timing was.
Yeah, but if that had happened very quickly, they might not have seen all of
Agreed.
it. Is that correct?
Agreed.
Yeah. Now, so it was not possible at this stage, was it, to give any indication about what the implications for the building regulations and the guidance might be, certainly on external fire spread?
No, I mean, as I said, what is written in this report is as much as we were able to ascertain at that stage of the investigation.
Yeah. Can you help us as to why this report doesn't identify anywhere within it that approved document B is silent on downward fire spread in terms of providing any specific guidance? Wasn't that something obvious to flag to the department, given that you are pointing out that there'd been fire spread down due to burning material falling?
I don't think I'd even gotten to the stage of stopping and doing, if you like, a review, a comparison of approved document B versus the findings from the investigation by this point.
Right.
I agree, it's something that ought to have been flagged, but I was, the contents of this report, I'd only just gotten prepared in time to issue this. That was as far as I'd gotten.
Yes. Yes.
And it's predominantly just focused on trying to get the facts down in terms of the way the building was put together and the sequence of events that occurred as far as could be ascertained at this time.
Yes, I see. if we look at the two headings underneath external fire spread, communications and guidance to occupants, can you see that under communications it's written, yes, communication between LFB and building occupants may require further investigation outside scope of this report. Guidance to occupants, yes, fire safety advice given to occupants by the landlord prior to the incident may require further investigation outside the scope of this report. Do you see that there?
Yes.
Was it considered that external fire spread would also require further investigation at this time?
Well, I suppose all of it required further investigation. As I said, the work wasn't complete. I suppose that the point with communications and guidance, it was clear from a very early stage that there were issues with advice that had been given to residents, both via 999 calls and in terms of what residents understood about the means of escape that were available to them.
Yeah.
So the purpose of putting those in under communications and guidance was to flag that these were clearly problems and significant problems.
Yes. But you've also said there was clearly an unusual pattern of downward fire spread. So what I'm seeking to understand is why don't we see similar language under that heading saying this requires further investigation, or at least may require further investigation? That's what I'm seeking to understand.
I think I know that it's probably a poor choice of language. The further investigation point is that it's not within the scope of the Investigation of Real Fires project to look at 999 communications. It could probably have been phrased better, but I would make the overarching point that this was a fundamentally incomplete investigation.
Yeah, I see.
And everything that is in it ultimately warranted further investigation.
Yeah.
This was about the scope and what the department decided to do with it as opposed to the state of the investigation as a whole.
Yeah. Now, if we can turn to some emails now. If we go to BRE 30043742, we can see there's an email here dated the 28th of July 2009. So that's before Mr. Martin has received the final version of this report on the 10th of August. Yes?
Yes.
But probably after he has received a first version of this report on the 16th of July 2009, yes?
Yes, and he would have received telephone updates and so on, those we discussed yesterday after the various visits.
Yeah. So this is Mr. Martin to Mr. Shipp, but you are copied in there together with others.
Yes.
And he says he says, Martin, for the purposes of the fire investigation contract you have with the department, I'm satisfied that there will be no need for you to revisit Lacanau House. Any further visits will need to be funded by a third party. And he goes on, I've raised this with colleagues in the FRD. Do you know what the FRD is? Is that the Fire Resilience Directorate?
That sounds correct, yes.
Yeah. And they are happy for you to step away now. Clearly, if the police or London Fire Brigade want to commission you to carry out further work, then we would have no objections. Best regards, Brian. Now, can you help us? What was your reaction to receiving that email from Mr. Martin at this stage?
I don't think, I doubt I was pleased. It was a time, I suppose I would describe it as a time of uncertainty because it was an investigation that I thought needed to be progressed and it wasn't going to be. And that's, well, as a result of that, attention switched. I think we'd had some discussions with the police prior to this time, but I don't think there was any substantial dialogue with the police at that time. So I suspect at that time I was expecting quite a significant possibility that would be it, and it wouldn't go any further.
Yes, I think earlier, when you were preempting where my questions might go, you said you were disappointed.
Yes.
Is that fair to say you were disappointed?
Yes.
To receive this email shutting down the investigation?
Yes.
Now, did you have discussions with Mr. Martin about his decision that you should step away, as he puts it in this email?
No, at that time it wouldn't have been for me to have such a discussion. It would have been between Martin Shipp and Brian Martin.
And can you help us? Are you aware whether those discussions did take place between Mr. Shipp and Mr. Martin?
I don't know, sorry.
You can't recall? No. Do you remember what Martin Shipp's reaction was to being told that you were to do no further work?
Probably the best description I'd put is resigned. He sort of, it was what it was. I don't think he was particularly pleased about it either, but it's a decision that they're entitled to make, I think was his take on it.
Yeah. So you can't recall whether there was any pushback from the BRE saying, hang on, we haven't even got to base one yet. We're just starting to understand some of what's gone on here. This needs further work. Do you remember that occurring?
No, I don't. But I mean, at this time, those sorts of conversations would have been above my pay grade, frankly. I was still a junior member of the team at this time.
I see. So you didn't suggest to Mr. Shipp that you should push back?
I don't think I would have suggested pushing back. I probably would have expressed my disappointment.
Right. And what was your understanding at the time about the basis on which Mr. Martin was making this decision? Did you have any conversations with him in which, or via Mr. Shipp, in which that was explained to you?
I didn't, but then I hadn't been, how do I put this? I didn't have a previous case of equivalent significance to benchmark against. It's not, I didn't have a point of reference in terms of whether this was an appropriate course of action or one equally that, had been taken commonly on previous such major incidents, or whether this was different to the normal course of things.
But you clearly understood at the time, yes, that the objective of this project was to work out whether there'd been a failure in the regulations or a failure of compliance, yes? And you clearly understood that you hadn't got anywhere near establishing that. But no reason was provided to you as to why this was being halted at this early stage?
No, I mean, probably. Sorry, I'm just trying to reconcile timings in my head. The police investigation was not of interest to DCLG, but I think from the point that the police was sort of taking primacy because there was a belief that there was a criminal case to be had, that was certainly presented as justification for it not therefore falling within the remit of this project. Yeah. But I can't say whether that had happened prior to this date or sometime after this date. But I do remember that link being made. Yeah.
Did Mr. Martin have any other information, so far as you were aware, which might form the basis of his decision to halt this investigation? Was he getting information from any other sources?
Not to my knowledge. I know there was some work done, I think it was around this time, so Martin Shipp had been separately, I don't know if he'd had meetings with or simply been in correspondence with Sir Ken Knight and equally Brian Martin separately about the government response to Lakanal and what, if anything, needed to be disseminated in the short term. But I wasn't party to any of that.
Right, okay. By this date, can you help us? Had you made Brian Martin aware that the relevant edition of the approved document for the purposes of assessing the refurbishment work was the 2002 edition? Had you made him aware of that?
Probably not.
Now, if we can turn to an email that you weren't copied into, I just want to ask you about this. This is at CLG 1003915. So you weren't copied into this email. It's an exchange between Brian Martin and someone called Glenn Horton at the time of Lock Carey, who we believe are a fire service consultancy. And the exchange occurs on the 13th and 14th of July, 2009. And if we look at the first email at the bottom of the page from Mr. Horton, sent on the 13th of July 2009, we can see that in summary, he's offering his assistance to the department in relation to the fire at Lakanal House. And in the final line of his email, he says, if there's anything I can help with, please feel free to shout. So, and in the email above that, paragraph above that, he says, I'm just dropping you a note to let you know if there's anything I can do to support CLG at this time or during any fire safety review. And then if we go to Mr. Martin's response at the top of the page, sent the next day on the 14th of July, he says this. He says, hi, Glenn. It has been a bit lively here. I even worked last Sunday, exclamation mark. Thanks for the offer of help. BRE have been on scene and we are waiting to see what they've found. Based on the snippets of info I've had so far, I don't think there's any need for changes to ADB, although people may be a bit more thorough when doing risk assessments. If there's an inquiry, they may be looking for independent experts. I'd be happy to put your name forward. Regards, Brian. Now, can you help us with how Brian Martin could have come to the view, this is just 11 days after the fire, that there would be no need for changes to approved document B? Can you shed any light on that for us?
No, I'm afraid not. Again, at that point in time, my work was still just focused on gathering evidence and compiling it and establishing what had occurred and when. Changes to ADB, I think that would have been a discussion between Martin Shipp and Brian Martin at that stage.
Right. But were you aware of them having had those discussions?
I was aware there were lots of discussions that were ongoing,
Right, I see.
but I wasn't party to them.
Yeah, because he's clearly suggesting in this email that BRE are on the scene, and he's had some snippets of info suggesting it's from the BRE that these snippets of info have come.
Yes.
So was it only Mr. Shipp that was that was providing Brian Martin with their updates other than you on this project?
I believe so, yes.
Yeah.
So I was, again, updating on what I was finding when I found it, and Martin Shipp would have been providing the overlay in terms of significance.
Right, yeah. And can you help us as to what Brian Martin is meaning there when he says people may be a bit more thorough when doing risk assessments? Can you help us with what might have been said about that at this stage?
I suspect, although I don't know, I mean, that was probably more focused on the internal fire safety defects that were present throughout the building. So there were various things which, because this was, it was fairly early on in the life of the regulatory reform fire safety order, and there had been quite a bit of interest, sort of ongoing debate about how one applies the fire safety order to blocks of flats and the extent to which risk assessments need to be carried out and so on. And in light of the wealth of deficiencies that we found within the building, it seemed clear that more thorough risk assessments that went intrusively into the building's fabric would be necessary, because some of the failings, frankly, ought to have been patently obvious to any fire safety professional had they looked in concealed spaces in the building.
Yeah. Now, we know that you established at a later stage, many months later, through testing various samples of the panels to BS 476 Part 7, yes, the surface spreader frame test, that the window panels could not achieve national class 0 and in fact were a class 3 in that test, yes?
Yes.
Not a class 1, which they would need to get, well, as part of the way to getting to national class 0, yes?
Agreed, yes.
Now that was many months later, it was in around November 2009, yes?
Yes.
Before we go on, those tests to BS 476 Part 7 were carried out on 3 types of the foam cored panels removed from Lakanal House, one with a pale yellow core, one with a pink foam core, and one with an orange core. Can you just help us? Why was that? Why was tests carried out on 3 different foam core colours?
Well, simply, we identified 3 different foam colours through the investigation. So a number of windows were disassembled initially simply as a result of standard evidence taking, if you like, in terms of trying to get some representative samples from the building that we could then decide what to do with later. It then became apparent, and I forget which, but we'd started out with the yellow foam core. Then either the pink or the orange was found, and as a result of that, we then conducted a more extensive check of all of the window panels to see how many different foam cores were present. And once we'd arrived at the 3 as being the end result, then the view was taken that we would need to see whether the different foam cores might lead to a different outcome in terms of the performance under the test.
I see. Okay. Now, Can we turn to some short emails between you and Mr. Martin in November 2009? If we go to BRE 43744. Now, the first email, it's the second one down on this page. It's dated the 18th of November 2009, and it's from Mr. Martin just to you. And we can see the subject is Lacanal House. And you say, Brian, would you mind giving me a call as soon as convenient, desk or mobile? Thanks, Dave. And then his response above that on the same day is, I'm out and about, I'll call in the morning. Now, can you remember, what was the urgency? Why did you want Mr. Martin to call you at this point?
The short answer is I don't, because I was trying to get to the bottom of this when I was preparing my statements. Given the timing of this, I did wonder whether it was the testing and because the Part 7 test revealed that the panels did produce chunks of burning embers. But I'm not, from the test reports, so certainly the dates of the test reports indicate the testing was largely carried out after this call. But it's not impossible that some of the early runs might have been carried out beforehand, and that's what prompted this call.
Yeah.
But I've been trying to piece this back from memory from a long time ago.
Yeah. So you think it might have had something to do with that Part 7 testing?
Yes.
But, we'd come to the same conclusion. Quite a lot of the test reports are dated after this date. Okay.
Yeah, I again, having reflected on this, I couldn't think of another reason why it would have been an urgent call to him.
Yeah.
But the timing doesn't quite sit well enough. I'm afraid I've not been able to bottom out how that all ties together.
Can I just look at what you said about this in your second witness statement at BRE 3043716, page 22, paragraph 78? Picking it up in that top line, second sentence, you say, I believe the FOSI report was emailed to DCLG on the 10th of August 2009. I also contacted Brian Martin via email on the 18th of November 2009 requesting a telephone call. This was around the time when the BS 476 Part 7 tests were being carried out. And then you say this, you say, I do not recall the specific nature of the phone call, but I do recall it being made clear to me at some point that the issue with the panels was one of non-compliance, not that the panels were somehow compliant and had produced burning debris in spite of being compliant. And you go on, you say, in addition, it remained the case that it was not possible to confirm whether the panels were in fact responsible for the burning debris which had ignited flats 37 and 53, or whether it was simply the contents of the flats that had produced the burning debris. Now, just to be clear, by this date, the department was no longer funding any investigation into the fire at Lacanal House. Is that right?
Correct, yes.
At this stage, you were now acting on behalf of the Metropolitan Police and the LFB, is that correct?
Yes.
And you tell us in your second witness statement, we don't need to go to it, that it was on the 17th of November that you were commissioned by the LFB to carry out some standard tests on sample panels taken from Lacanal House, yes?
Yes.
So that was the day before this email, the email that we looked at.
Yes.
Now, looking at what you say there in that paragraph, you very clearly say, I do recall it being made clear to me at some point that the issues with the panel was one of non-compliance. Are you saying that Brian Martin communicated that to you?
Probably, yes. This is the point. I'm not 100% sure that it was Brian Martin, or it might have been Martin Shipp, but the point that was made to me was broadly along the lines that had the panels been Class O, and bearing in mind the performance that's needed for Class O, then by extension you wouldn't have had them burning to such an extent that they would have then produced these fragments of burning material in the same way.
Yes, but if the Part 7 tests hadn't yet been carried out...
Yeah, no, I'm not sure of the timing of that, when that was communicated to me. Or the point
Right.
I'm simply making is that I do recall that point being made to me.
I see. So are you saying that that point was not necessarily made clear to you in that call, but it was made clear to you at some time?
At some time, yes, correct.
I see. But why were you were the person investigating the fire, why were you being told that the issue was one of non-compliance rather than any other problem? Why wasn't that something that you were investigating and then communicating back to the department?
Because, so in the context of the criminal investigation, the burning debris, what's the word I'm looking for? It wasn't relevant because there was no potential offence associated with the production of burning debris. So even if the panels were the source of the burning debris, the fact that this wasn't controlled or had relevant recommendations in approved document B meant it would be incredibly difficult, if not impossible, to achieve a prosecution to the standard of beyond reasonable doubt.
Yes,
So,
I understand that about the criminal investigation. I understand you're saying...
I'm coming back to that.
Okay.
So the point is, and this is why I've been struggling with what was discussed during that phone call, it was fed back, I'm sure, that the panels were producing burning embers, which fell out of the test rig on the Part 7 test when conducted. And that was fed back because, it wasn't something that could be covered by the criminal investigation, but it was something that DCLG needed to be aware of. But the view was put back to me as to what would have been the outcome had the panels been Class O, that they wouldn't therefore have produced the burning debris.
Right. And this view was put back to you by who?
Again, I'm not sure, but I believe it may have been Brian Martin or Martin Ship.
Right.
It was the logic that was put to me because to achieve Class 1, the flame spread across the specimen has to be, I'm probably going to get the numbers wrong, but something in the order of 65 millimetres across the sample. The rest of the specimen is therefore unaffected by the test, in effect. So you wouldn't have substantial quantities of the specimen becoming alight and therefore producing burning debris, which could then have these other knock-on implications for the incident. And so what was believed by what was put to me was that the burning debris simply wouldn't have occurred had the panels been Class O.
Right, I see. But I'm still puzzled as to why that's not something we see in a report from the BRE to the department formally saying, we've done this tests, you might want to be aware that this is how they performed, it shows this about the regulations or that about the regulations. Why don't we see that?
I don't know. I mean, I probably... There would have been an element of restriction placed upon what could be released from the police investigation. I don't think they would have prevented this kind of issue being fed back. And it would probably have ultimately been a decision for Martin Ship as to whether and in what form it should go back separately to the department. But it was flagged. I believe it was flagged, at least informally.
Yes, you say, I believe it was flagged at least informally. Is this all going on in verbal conversations? Is that what's happening here?
Yes, what I've described there is, yes, it's verbal conversations.
Yes. So you've got an ongoing contract, haven't you, under the investigation of real fires contract to be reporting back on fires, yes?
Yes.
And you've got an obligation to, you're supposed to be communicating to DCLG whether or not there's been a failure in the regulations or just a failure to comply. And yet what seems to be happening is a series of verbal conversations are going on based on tests done at the LFB, in which it's decided that we don't need to look any further and it's just a question of non-compliance. Is that what happened?
Yes, probably, but I was only partially involved in the conversations with DCL. So I would occasionally get a phone call with Brian Martin if I felt it was particularly warranted or relevant to do so. But as a junior member of staff at the time, I wasn't encouraged to speak directly to Brian Martin. Most of the communication was supposed to go through either Martin Shipp as the project manager or even Debbie Smith as the framework manager.
Yeah. And can you help us? Were you told that it was an issue of non-compliance with the regs before the results of the Part 7 tests or after? Can you help us with that?
The point about the non-compliance.
Yes,
Sorry,
you said it was communicated to you that it was a non-compliance with the with ADB that was the problem here, not a problem with the regulations. Was that communicated to you before the results of the Part 7 tests were in or after? Can you help us with that?
Probably after.
Right. And when you say you were only partially involved, is it your evidence that Martin Shipp was leading this from the BRE at the time, not you?
Well, he was leading the investigation of Real Fires project. He was overseeing my work for the Met as well. I mean, the intention, certainly at this time, was not for me to be the expert witness on the Lackland investigation. I was just the junior staff, doing the work, and Martin was ultimately going to be the person that took this forward to a trial or anything similar. So,
Right.
Yeah.
Right. Did you mention your concerns about downward fire spread to the department and to Mr. Martin at this stage?
So in November 2009?
Yeah.
Yes, I mean, the link would have been made that there was the downward fire spread that's already been reported, and now we have these test results that confirm that the panels themselves are producing debris.
Right. You considered that downward spread was unusual still
Yes.
at this point, yes? Let's just go to your second witness statement again at page 18, paragraph 61. And you're answering the inquiry's questions here about the reconstruction that you carried out of the Lacknell fire at a later stage. And you explain there that the reconstruction did not and was not intended to address any aspect of the downward spread of fire at Lacknell House. That's right, isn't it?
Yes, that's correct.
And that reconstruction was, you say, focused squarely on matters which could lead to a criminal prosecution. Is that right?
Yes, correct.
And in the final line of 61, lines of paragraph 61, you say this. You say, downward fire spread was not addressed by the provisions in approved document B at the time, so offered no prospect of prosecution. Yes?
Yes.
Now, I understand that in relation to a prosecution. You can't prosecute someone if well, this is what you say, you can't prosecute someone if ADB didn't give guidance saying you should avoid downward fire spread and regulate the droplets that should be produced by these products. I understand that point. But just thinking back to this broader ongoing contract that you have with the department to identify potential safety issues and regulatory issues under the investigation of Real Fires project, why did you not raise the matter of downward fire spread with Brian Martin as part of that wider context of reporting on matters of public safety?
Do you mean at the time of the reconstruction, or at what point? Do you mean just generally?
Well, let's have a look at it. Let's look at an investigation of Real Fires report that was dated the 17th of November 2009. This is at CLG 30s19142. This covers the period of the Lacknell House fire, dated the 17th of November 2009 in the bottom right-hand corner. Now, this doesn't contain any recommendations about changes to ADB or further work that ought to be carried out following the Lacknell House fire. If we go to page 3 of this report, we see at the bottom of the page, it's there, penultimate paragraph, we get the familiar phrase, the findings from this project have reaffirmed the overall effectiveness of the building regulations and ADB in providing for the safety of life in the event of fire. And most of the significant issues that have been identified during this study fall outside the scope of these regulations. Now, on page 16, if we go to that, we can see in the middle of the page, in the last bullet point, we see something said about Lakenall House. It says the fatal fire at Lakenall House, Camberwell, has focused attention on blocks of flats and the responsibilities of the owners of the properties to satisfy the requirements of the fire safety order. This incident is still subject to a Metropolitan Police investigation. More information from this incident of relevant to communities and local government will become available once this investigation is completed. So it does say that about the police investigation, that it's ongoing. But it doesn't say anything about downward fire spread or about the fact that ADB doesn't provide for anything in relation to that, or the fact that that ought to be investigated further. Can you help us as to why that is?
No, I doubt I was involved in writing this report at this time.
Well, let's look at page 2 of this report. Sorry, page 2. You are one of the authors listed at the beginning. It says prepared by Martin Shipp, Kelvin Annable, David Crowder.
Yes, no, absolutely. I would have, well, I did. I'm sure I wrote up various of the appendices, so the fires that were attended and written up as fires of special interest reports. But I don't think I was involved in compiling the overall report and producing the front-end findings at this time.
Right. Is it your evidence that if you had been more involved, that there was more you would have said on that topic at this stage? Because we've agreed, I think, that it was unusual to have this downward fire spread. It had serious consequences, didn't it, the downward fire spread at Lakenall House?
Yes.
Why is it not flagged in this report? And would you have flagged it if you'd written it?
I would. How do I put this? If I were then in the position I came to hold later on, then yes, I would. But I don't, even if I had been involved in, I may well have been involved in discussions around the conclusions. It wasn't ultimately my decision how they were drafted and what was ultimately submitted.
And whose decision was that?
Martin Shipp.
Do you remember discussing with Martin Shipp the fact that you perhaps ought to be flagging in this report that downward fire spread was something which needed to be investigated, which wasn't addressed in approved document B, and ought to, be the subject of some further work?
I remember discussing the burning debris with Martin Shipp. Whether it was in the specific context of this report, I can't recall, but I certainly had conversations about the debris.
Yes. You make the point several times in your statement that it wasn't possible to tell from the incident whether it was burning debris from the contents of someone's flat or burning debris from the panels which entered the flat. But when you did the Part 7 tests, there was burning debris from those panels observed, wasn't there?
Yes.
I'm going to take you to some of the observations in those tests. Surely the fact that it might have come from the contents or it might have come from those panels, once you know those panels are producing burning debris, isn't that no longer a good reason not to take things further?
Sorry, take things further in what way?
Sorry, I'm not being clear enough. You seem to say in your statement that the reason why this downward fire spread wasn't looked at further, or some of the reasons you give, is because in the incident it simply wasn't possible to tell from a causative point of view which type of debris it was. But once you know these panels are producing that kind of debris, why does it matter whether in that particular incident you can kind of deal with the causation problem? Why aren't you investigating it nevertheless and advising government to investigate it nevertheless?
I mean, I think I did flag it as something that needed looking at, but it wasn't ultimately my decision whether or not it was.
And when you say...
I did try I went to all the various flats on that elevation to try and identify what kinds of debris had fallen in through windows, where things had caused scorching to the window surrounds, but hadn't actually quite been sufficient to cause fires to be ignited within those flats.
Yes, I understand that, and I understand that was a relevant part of the investigation to see if you could establish definitively what had actually caused the downward fire spread. But my point is this: once you know those panels are producing burning debris, isn't there a real problem there that you need to be flagging to the department, regardless of whether, in fact, at Lacknell, that was the piece of debris that set fire to that flat?
Okay, so, well, yes, that was flagged.
How was it flagged?
So for my part, it was during the discussions with Brian Martin. I can't speak to what other discussions took place. But the view was, A, the panels were not compliant, and had they been, they wouldn't have been burning debris. B, the other view that was put forward was, well, the flats themselves were producing loads of debris, and this would always be the case anyway. There was pushback, for want of a better word. It wasn't something that was being taken particularly seriously, not by me, but by those I was talking to.
I see. So just to be clear, you did flag this issue with Brian Martin, yes? This issue of downward fire spread and debris coming from the panels. And you're saying that it wasn't being taken seriously. Is that your evidence?
It was, sorry, not taken seriously is probably the wrong turn of phrase. It was considered by them that there were other explanations for this that didn't go back to a fundamental problem with the approved documents, I think is the impression I get.
Right. And who gave you that impression?
Brian Martin.
Right. And did you push back on that and say, well, that doesn't matter. We clearly have a problem with burning debris with these kind of panels, and you've got a problem because approved document B doesn't say anything about burning debris. That's a gap. That's a problem. We at least need to do some further work to investigate this further. Did you push back in that way?
A little, but again, we're into conversations that were above my position at that time. Yes, I mean, I flagged the issue. I went back to Brian when I thought it resurfaced, but there's only so far I could go in circumstances where, again, junior staff were not encouraged to talk directly to DCLG.
Right, I see. So did Mr. Shipp actually tell you not to talk directly to DCLG about these kind of matters?
No, but there was an email from Debbie Smith. I think it was during the new framework. So, sorry, not at the time. So, in the years preceding this, when apologies, I think it's in my third witness statement. One of the frameworks, and I think it's the framework that immediately preceded Lacknell, there was an email sent out by Debbie Smith that specifically made clear that we, the fire safety staff generally, were not to discuss matters directly with DCLG unless they were within sort of formal meetings with Debbie Smith and or other senior staff as the framework managers.
Right.
We were discouraged from having sort of sidebar conversations with DCLG.
Right. Okay. And tell us this, in the years later, when you did become more senior, why did you not flag it then in a formal report to the department as part of this ongoing investigation of Real Fire's contract?
Well, in the years later, it had been flagged in the inquest to which Brian Martin was a witness, and we'd had those discussions. I mean...
Sorry,
there is a point.
What are you saying had been flagged in the inquest? Downward fire spread and the burning debris? You'd had that conversation with Brian Martin then, had you?
Sorry, I mean the findings from the inquest themselves included the issue around external fire spread, that there needed to be work done on external fire spreads, because the point was made, I think, in the Fires of Special Interest report, that once the investigation was completed, there might be a further information, there might be a further update to the report. But ultimately, once the inquest was concluded, and there was a very a formal, and I would argue a stronger set of recommendations made to DCLG under the powers of the Rule 43 letters issued by the coroner, what was needed had then been formally communicated to DCLG.
I see. Now, if we go to your second witness statement again and look at paragraph 69 on page 20, that's BRE 3043716, page 20. In the first line there of paragraph 69, you say this, you say, I raised the unusual nature of the downward fire spread on every occasion that I gave a presentation on Lakanal House. See my previous witness statement. Now, can we just look at the what we think is the BRE Lakanal master presentation? That's at BRE 405884. So the title of this document was the BRE Lakanal Master Presentation, and this seems to be like a template presentation. It's quite long. If we look at page 51, we see the conclusions. Is this a familiar presentation that you can see?
Yes, I prepared it.
Lakanal House, yeah. And so starting with these conclusions, actually on 51. We can see it says, building considered state of the art when built, featured in Architect's Journal, large number of issues crept in over a number of years, overall worsening conditions through years of neglect, no one single factor sufficient to have caused death in isolation. Do you see that?
Yes.
So there was nothing in these conclusions about downward fire spread or its unusual nature, was there?
No, but this slide didn't cover any of the fire safety issues in detail. They're in the preceding slides.
Yeah. Let's have a look at page 11, where you deal with the cladding. You've got flat 65, fire development, and you can see in the final bullet point there, it says fire damage extending up external facade to flat above, flat 79. If we look at page 18, there you're dealing with the standard test. Is that a photograph from the Part 7 testing that you did?
Yes.
So we can see it says preliminary modelling and testing, standard test, BS 476 Part 7, spread of flame, window panels, door panels, balcony panels, and then some of the other tests that you did on spread of flame and smoke toxicity. So we see that on page 18. We go to page 24. There's a slide on the composite panels, compressed resin outer layers and foam insulation core, class 3, no fire resistance. Ignited under flame impingement from burning flat below, burnt through in 4 to 5 minutes. You see that. And if we go to page 25, there's something on balcony flat doors about when they were introduced. And if you look at page 38, there's a timeline of fire spread to flat 79 and downward to flat 37 and 53.
Yes.
Do you see that? But we can't find any mention in this master presentation, any specific mention of downward fire spread, of the unusual nature of downward fire spread, of falling, burning debris or molten burning debris from the panels. Why not, if this was such a big focus of these presentations?
Is it not mentioned on the slides relating to flats 79, 37 and 53? You went to the slide on flat 65, but
Yeah.
we didn't cover the slides concerning flats 79, 37 and 53.
Okay, well, I'll tell you what, we'll have a look at that in the break and we'll come back to it if it's mentioned there.
Okay.
Actually, if we look at page 16, is it flats 37 and 53 you're wanting? Is that what you're referring to?
Yes.
Yeah.
So, I mean, I talk, so with these presentations, and it's a presentation style that I have, I as I got better at giving presentations during my career, I moved very much away from being a presenter that just reads the slides to the audience, because I don't think that's a particularly good way of giving presentations. So I try and give very succinct slides that are sort of visually interesting to the audience, and then I talk. I mean, I would quite happily talk for anywhere between 5 and 15 minutes on any one of these slides about the issues that surrounded these points. So the content that I delivered, and equally, the amount of content was somewhat dictated by how much time people would make available for these presentations, but the content was much broader than what is simply contained on the slides.
Yes. So is the answer no, there isn't any express reference in these slides to downward fire spread, but you think you might have said something orally?
I mean, I do believe there is a reference in here somewhere, but I would definitely have discussed this orally during the presentations.
Yes.
Not least, I mean, the specific point, if you like, in terms of the patter that I had when I went through these was going through the timeline at the end. The point about, flats 37 and 53 igniting as a result of the debris that's coming out of the fires, and then the impact that has on the firefighting operations. That was all part of the story that I got very used to telling with this presentation.
Yes, I see. Yes. Can we just have a look at the contract that the investigation of real fires contract that you were operating under at this time, BRE 500951. So this is the October 2012 version of this contract. And if we look at page 44, in the second paragraph down, do you see that there's a sentence that reads, second paragraph down from the top, BRE will maintain informal, direct and regular contact with DCLG policy officer and project contract manager as appropriate during the course of the contract, yes?
Yes.
So can we be clear that even after there's this restriction on you making policy recommendations that we discussed yesterday, there was this obligation to maintain informal, direct and regular contact with DCLG policy officers, yes?
Yes.
Now, is what you've just said a moment ago about the email you say you got from Debbie Smith saying you can't have informal contact save for informal meetings, does that mean that you weren't having informal, direct and regular contact with DCLG policy officers after this point in order to raise points about, say, the adequacy of ADB?
It means that I wasn't, but it doesn't mean that BRE wasn't. I mean, again, over time, as I became more senior, then it was more accepted that I was having regular contact. So it's more a reflection of seniority within the organisation and the organisation as a whole. Yeah. I believe others, and again, so early during my career, Martin Shipp and Debbie Smith would have been the ones having the regular informal contact, and as I made my way up through the ranks, and my contact increased.
Right. Can you help us with this? Did you ever offer or ask to prepare a separate policy implications report on downward fire spread?
No.
Now, looking again at your third witness statement, this is at BRE 3047668. And on page 37, paragraph 156, yes, there, we can see that you say, in the last 4 lines, by the time the MPS investigation had been abandoned in May 2012, there was an express requirement by DCLG for BRE not to make any policy recommendations. Do you have that?
Yes.
Now, can I just tease out something about the timing of this, though? Can we agree that, in fact, the previous contract with the DCLG remained in force until July 2012? Were you aware of that? So the contract which didn't say anything about not making policy recommendations, that was in force until July 2012.
Agreed, though, so apologies, that's my mistake. Prior to that new July contract, there had been this shift, albeit that it wasn't, because the old contract was 3 years old, it wasn't recognised within the contract, but there had been a shift by May 2012 that they didn't want us to be providing policy recommendations. That wasn't then formalised in the contract until a couple of months later, but the direction of travel, if you like, was very much well understood by that stage.
I see. Because what we're seeking to understand is why, even if you had to wait until the end of the MPS investigation being abandoned, why after May 2012 there couldn't have been a recommendation to make a policy recommendations report, a policy implications report on downward fire spread, why that couldn't have happened.
Everything, I mean, from that sort of time, there was this unwillingness to hear policy recommendations from DCLG, and so not in May 2012, but not very long thereafter, the focus shift towards the inquest, given that would provide, outside of the contract, a clear route by which recommendations could be made.
I see. Yeah. Can I just look at your third statement now, at page 39, paragraph 162, and I want to pick it up in the second line. You say this: as explained in my second statement, the reconstruction was funded and carried out to support a criminal investigation. There was nothing to be gained from trying to replicate the burning debris in terms of establishing whether offences had been committed. And then you say this: in any event, even if this had been a piece of government research, the fact that the panels were capable of producing burning debris had already been established by the BS 476 Part 7 tests carried out a month prior to the reconstruction. Now, do you accept that the mere fact that the panels were capable of producing burning debris did not take the understanding of the phenomenon of downward fire spread any further?
I'm not sure I follow the question.
So what I'm really seeking to tease out is that you've established that these panels are capable of producing some burning debris, but actually understanding in detail what the mechanism would be for any downward fire spread, how that would happen. Is it that, a melting and dripping of the plastic? How does that occur? How does it pool? Are there pool fires? All of that complication, which can be looked at when you analyse carefully something like downward fire spread, that hadn't been gone into at all, had it?
Not as a broader topic. In terms of Lacanol, it had been established because what the test showed was there was no melting. These were panels which formed a char. So effectively what you ended up with was embers, like you would get from a fire, that were falling off of the panels as they burnt. So as far as Lacanol was concerned, the downward fire spread was well understood. And that, in combination with some of the computer modelling that was conducted in relation to the fire, led us to understand that, whatever the burning material was, whether it was fragments of burning panel or fragments of burning material from inside the flats, it was the very peculiar set of air currents that occurred on the day of the fire that happened to result in debris falling into the flats below and therefore igniting them, and what transpired as a result.
Right. Where you say there was no melting, these panels formed a char, so effectively what you ended up with was embers, like you get from a fire. Why don't we see that written up anywhere by the BRE in a formal report so that others can understand what the mechanism of the downward fire spread was?
I believe that's in the reports for the standard tests.
In the 476 Part 7 test?
Yes, I believe so.
I see. Now, is it right that the window panels used in the refurbishment of Lacanol House, which were found not to be able to achieve National Class Naught, were identified eventually as being formed of two 3mm outer skins of Trespa Meteon, a high-pressure laminate, yes?
Yes.
And we know there was this foam core sandwich between them, yes?
Yes.
If we go to your second statement at page 12, paragraph 35, we can see that you're responding to the inquiry's question just above paragraph 34. And the question is this: did you or anyone else from BRE take any steps to identify the foam cores? Do you have that?
Yes.
And your response below that, paragraph 34 and 35, is this. So at 34 you say, I sought out the information which was available in the witness statements taken by the Metropolitan Police, which indicated that the panels had been manufactured by at least 2 companies, and you name them. And you say I made a request for further information concerning the insulation used in these panels, but none was found prior to the decision by MPS to discontinue its criminal investigation. And then you go on, you say in terms of laboratory activities conducted at BRE then, other than visual inspection, no steps were taken to identify the foam cause. As previously set out, doing so would have been of no value in terms of whether or not the panels were compliant. Had information been obtained from the manufacturers, then I believe it would have become necessary to conduct chemical analysis to match the panels to manufacturing information. And then if we look at paragraph 37 at the bottom of that page, you say, so you're being asked to describe steps in detail, and the answer you give is, as above, the specific chemical composition doesn't affect whether a material is compliant, legal, non-compliant, legal, illegal. It is the fire performance which determines this. Establishing the exact chemical composition of the cause would have added no value in terms of whether or not the panels used were compliant and or gave rise to any criminal offences having been committed. So is this right, that in your view the chemical composition of the foam was not relevant to compliance or non-compliance? The fire performance would be the determining factor, yes?
Yes.
But can we agree that the fire performance of the foam cause wasn't established clearly either, was it?
I'm not sure we can agree that. In what sense? I'm afraid you'll have to explain.
So no specific tests were carried out on that foam core itself, were there? You did a 476.
Oh, I see.
You did a 476 part 7 test on the composite panel. Yes. But you didn't do any kind of testing, did you, on the foam core itself at any stage?
No, because there were no performance requirements specific to the foam core as an isolated material.
But did you not want to understand what the fire performance of that foam core was?
As an individual material, no, we wanted to understand the performance of the composite panel as a whole.
If we look at page 14 of your second witness statement, you're asked at D by the inquiry, did you give consideration to the performance in fire and or the combustibility or otherwise of the foam cores of the panels? And you say this, you just say, see previous responses, the performance of the foam was necessarily affected by it being sandwiched between 2 sheets of Trespa, just as the Trespa performance was affected by the insertion of the foam. Testing the foam in isolation would not have yielded a result that could support a criminal prosecution, as there was no performance requirement recommendation specific to the foam core, given that it was insulation not within a ventilated cavity, and the building work in which it was installed was subject to approved document B 2000 edition, consolidated with 2000 and 2002 amendments. Now, I understand that what you're saying is if you tested it in isolation, that wouldn't have supported a criminal investigation. But weren't you, as the BRE, interested in understanding what the fire performance of this foam core was, regardless of whether or not that was useful in a criminal investigation?
BRE might have been, but I certainly at that time it wasn't at my discretion to go spending money on those sorts of things absent a contract to cover it.
Did it ever occur to you that that might be a useful piece of research to recommend to the department that they carry out?
Probably not as just establishing the performance of the individual foam core. I mean, I did at various times try to think of, what further areas of research might be derived from Lacanau. It was something, in fact, that I started putting my mind to when the fire safety prosecution was finally concluded. But that obviously never happened because it was only a few months later that the fire at Grenfell occurred. But no, at that time, I wasn't in a position to be thinking about what other things that BRE could be doing, say funded by the BRE Trust, to further investigate this.
Now, it was your view, wasn't it, that the insulation in these panels was likely to have been polyurethane or a similar material? Is that right?
Yes.
That was the evidence you gave to the coroner at the inquest in March 2013.
Yes.
Polyurethane's a combustible material, isn't it?
Yes.
Can we look at your report to the Metropolitan Police now at BRE 405881? So this is your expert witness report, 11th of May, 2012. The date's right in the bottom right-hand corner. Now, the insulation product used as the foam core is addressed in this report. If we go to page 97, in this section of the report, what you're doing is commenting on the witness statement. If you look in the middle of the page, you can see there's at paragraph 541, it says S250, Symphony Windows Manager, Nick Coop, yes?
Yes.
And what you appear to be doing is commenting on a witness statement that this individual, Nick Coop, had provided of Symphony Windows. And if we go to page 99, paragraph 551, so right in the middle of the page is an indented paragraph, paragraph 550.1. And in the second line, you say, thermal performance of insulation materials is becoming increasingly important with the current drive towards sustainability. However, this does not diminish the requirements with respect to fire safety. Do you see that?
Yes.
And then staying on that page and going down to paragraph 552, we can see that Nick Coop has explained in his witness statement, there's some text in italics. He said this at paragraph 3. He said, with reference to the infill panels, it would be unusual for us to deviate from the sandwich panels, but we may if, for example, a backup panel was required on the inside. The insulation in the panel is a high-density polyurethane board, which is commonly used in the industry, and I am not aware of any alternatives for this type of installation. Although I believe polystyrene is still used in some installations, but it's not a product we would consider. And then he goes on. It is my understanding that polyurethane insulation meets recognised standards of fire safety. Do you see that?
Yes.
And you comment at paragraph 552.1 at the bottom of that page. You say this, you say the fire performance of polyurethane is variable and dependent upon the way in which it is manufactured. The term polyurethane refers to a family of plastics rather than an individual plastic. Polyurethanes most commonly vary either through their core chemistry, i.e. which ingredients are used to actually produce the polymer of the plastic, or through the overall formulation of the plastic, i.e. using additives which are mixed into the formulation but do not chemically react with the polymer when it is produced. Fire retardants can fall into either of these two categories. Do you see that?
Yes.
Now, just with reference to that, can we agree that the fire performance of the particular polyurethane foam used in the panels at Lakanal House was not examined at any stage, was it?
Agreed. Yes.
Thanks. And before we move away from this document, if we turn to page 117 and to paragraph 653, we can see there's a heading there above that, letter from the principal construction professional at DCLG. Now, this is a letter that the police had received from Brian Martin at DCLG. And you tell us at paragraph 653 of this report, I've reviewed a letter from the principal construction professional at DCLG in response to questions that were posed by London Fire Brigade in relation to the requirements of the building regulations and the recommendations of approved document B. This letter has been provided to me by MPS and can be identified within their document management system. Do you see that?
Yes.
Now, we'll go to that letter in a moment. That's a letter from Brian Martin. Moving down this page, we can see at paragraph 656, you say, The provisions for external walls of buildings where walls are above 18 metres are confirmed as being as follows. Insulation in the external walls should be either of limited combustibility or the entire wall system should be tested to BS 8414. So you appear, is this right, to be confirming to the Metropolitan Police information which had been given to them about guidance in approved document B by Brian Martin, yes?
Yes.
But that information was not correct, was it? That the insulation at Lacanau House needed to be either of limited combustibility or the entire wall system tested to 8414.
No, I don't know why it doesn't include the reference to ventilated cavities. I take it that's the point you're
Yeah,
making.
precisely.
Yes.
It's a point you yourself make at paragraph 44 of your second witness statement. You make the point that there was no performance requirement or recommendation specific to the foam core because it was the 2002 edition of approved document B which applied and which only required insulation in ventilated cavities to be of limited combustibility, yes?
Yes.
And Lacanau House was not a ventilated cavity system, was it?
No.
Now, were you aware of this at the time you prepared your report for the police in May 2012?
Yes, I think so. I mean, there's an entire section in this report devoted to approved document B 2000, which I think includes those provisions. I think it's section 3 of this report, deals with legislation and guidance.
But can you explain why you appear in this section to be endorsing the letter from Brian Martin about approved document B, which says that the insulation should be of limited combustibility?
This section of the report is not concerned with endorsing things. It's a review of documents and what they say. There may be a transcription error in. You say you'll bring up D371 later, but this part of the report is not concerned with endorsing that view. It is about gathering the information and then the conclusions and the implications in terms of the potential for trial and so on come later.
I see. Mr. Chairman, I'm going to go to that letter, but I think let's break now and we'll do that after the break.
Right. Dr. Crowder, we'll have our morning break at this point. We'll stop now. We'll resume, please, at 20 to 12. And as I said to you on previous occasions, please don't talk to anyone about your evidence while you're out of the room. All right?
Thank you.
Thank you very much. Thank you very much. 20 to 12, please. Would you ask Dr. Crowder to come back in, please? Thank you. Right, Dr. Crowder, all ready to carry on, I hope.
Yes, thank you.
Thank you very much. Yes, Ms. Green.
Yes, thank you. Just picking up on the first point from this morning's evidence, in the light of your answers, we've rechecked that presentation that you gave on Lakanal House, the slides, and there is no reference to downward fire spread anywhere else in the slides that we can see.
Fine. I thought there was, but I mean, as I said earlier, I would have discussed the point while giving the presentations anyway.
Yeah. Then going back to the point we were on just before the break about your report to the Metropolitan Police and what you were telling them about the relevant provisions were within the approved document, if we look at page 179 of that report, sorry, I probably need to give the reference again for it. So, yeah, BRE 405881. Yes. So if we look at page, 179 and paragraph 995, when you're going through the regulations, we can see at 995, you've stated that paragraph 13.7 of ADB states that the external envelope of a building should not provide a medium for fire spread if it's likely to be a risk to health or safety. And then the use of combustible materials for cladding framework or of combustible thermal insulation as an overcladding or in ventilated cavities may present such a risk in tall buildings, even though the provisions for external surfaces in diagram 40 may have been satisfied. Do you see that there?
Yes.
So you've got reference to that part of ADB and the fact that it's in ventilated cavities that the combustible insulation is a problem. Yes. But if we go back to the page I was on, which was page 117, the way this part of your report reads to us is that you're confirming information that Brian Martin has given in his letter about the relevant provisions of ADB. And the reason for that is if you look at, say, paragraph 654, do you see you start that paragraph, the letter confirms that. Do you see?
Yes.
And then at 656, you've got the provisions for the external walls, where the walls are above 18 metres, are confirmed as being as follows. Insulation should be either limited combustibility or entire wall system. So help us with this. Why, if you did clearly understand that it was only insulation in ventilated cavities that needed to be of limited combustibility, why, when you're reviewing this letter, don't you correct that or make reference to the other paragraph in your report and say, well, actually, he's got this wrong. These aren't the right provisions in approved document B. Can you help us with that?
So in terms of the meaning of the word confirm, I think, and well, we'll go to the document, I believe you said, but that was what the responses provided by the principal construction professional confirmed the following. That's what confirmed means in this context. As to it being correct or not, I don't know. Thinking back, it probably didn't jump out off the page at me that it was a fundamental incorrect point to make. I mean, the point was that I was aware of what the relevant performances ultimately were that needed to be achieved, and that was then set out in relation to the ultimate findings of the report.
But it's crucial for you to be clear in the report about that for the Met, isn't it? Whether there was a requirement for the foam core to be of limited combustibility or not.
Yes, agreed, but I believe the end conclusions of the report do address that properly.
Let's go to the letter from Brian Martin that you'd reviewed in this part of your report. It's at CLG 1004684. We can see from page 1 that the letter is dated the 23rd of February 2011. And it's to the Assistant Commissioner of Fire Safety Regulation at the London Fire Brigade headquarters. Do you see that?
Yes.
And if we go to the second paragraph on page 1, halfway through the third line, so let's just read the whole second paragraph. He says, "You will appreciate that I cannot give a definitive determination of the law as it is a matter for the courts. However, I hope the following responses to your questions are of assistance. I have answered your questions in relation to approved document B, volume 2, buildings other than dwelling houses, based on the current 2006 edition, which took effect in April 2007. You may need to check that this edition is relevant to any building work that may have taken place." Do you see that?
Yes.
So he is making clear that he's based his answers on the 2006 edition.
Yes.
But help us with this. This letter is from February 2011, so more than 18 months after the fire at Lakanal House. Can you help us to understand why Brian Martin is essentially asking the LFB to check that the edition he's referring to is the one that's relevant to the building work that took place at Lakanal House? How come he doesn't know that by this point?
I don't know why he doesn't know that by this point. I would have thought he did know that by this point, although just returning to your earlier questions, I mean, this now makes sense to me in that he was asked to confirm things, so I've recited what he confirmed, and
Yes.
the reason why I wouldn't have corrected him is because insofar as he's commenting on the 2006 edition of ADB, there is nothing incorrect about the information he provided, but I still drew my own conclusions in terms of the expert witness report that ultimately it was the 2000 edition that applied, and therefore we weren't interested in limited combustibility for the insulation. But why he chose to rely upon the 2006 edition, I do not know.
Can you help us? How could Brian Martin have decided that there were no problems with ADB itself arising from the Lakanal House fire when he doesn't appear to know what edition of the approved document is relevant to it?
As I said, I think he did know. I don't know why he chose to refer to that edition.
But as we've discussed before, the difference between the 2002 edition and the 2006 edition made a big impact, didn't it, in terms of the core of the foam panel at Lakanal, because on the earlier version it didn't need to be of limited combustibility, on the later version it did.
Yes.
Now, if we go to your second witness statement to the inquiry, at page 14, paragraph 44, we read this earlier, and I want to just ask you some more questions. You seem to be explaining in this paragraph that the basis for the decision not to identify or assess the fire performance of the insulation was that in the absence of any performance requirement for that material, the results, whatever they were, couldn't support a criminal prosecution, yes?
Yes, that, and that ultimately what was of interest in terms of performance was the composite panel as a whole, not the insulation in isolation, and equally not the Trespa in isolation.
Yes. Why do we not see that fact, the absence of a performance requirement for the insulation, very clearly set out in your report to the police?
Because it would have been a very long report if I'd identified everything that wasn't required. I identified the things that were required. The police, I mean, to their credit, they don't do fire safety prosecutions very often. They wanted a report that was as succinct as possible, so I told them what things were that were required, and that therefore might give rise to further investigation and prosecutions. But I wasn't going to list out to them all the things that ultimately weren't relevant to them.
The lack of any fire performance requirement in the relevant edition of approved document B for the foam insulation was also not mentioned at any time during your evidence at the inquest into the deaths of Lakanal House, was it?
No, because I wasn't asked any questions on the subject.
do you consider that the fact that the polyurethane insulation used in the external wall arrangement of Lacknell House was compliant with the provisions of approved document B in terms of its combustibility exposed an obvious flaw in the 2002 edition of the approved document?
Yes.
Now, why is that not flagged up somewhere in any of your reports?
Well, I mean, there wasn't a vehicle in terms of, so the fire of special interest report was closed off prior to it being fully fleshed out with these kinds of issues. The police investigation, as I said, was concerned with what things were required and therefore what potential offences had been committed. I don't know why it wasn't raised during the inquest, but just as I am here responding to your questions today, I can't just speak at will on subjects that I'd like to cover.
I understand that.
The same is true of the inquest. It was for counsel to the inquest and indeed the various interested parties to decide what topics they wanted to ask me about.
But do you ever remember discussing that obvious flaw with the department, with Brian Martin?
Yes, I think I couldn't say exactly when, but I'm sure it did come up, and the point that was immediately made was, well, this isn't an issue anymore. We've corrected that in the 2006 edition. I do remember having that conversation, but
Right.
as I say, I couldn't say exactly when.
I see. Now, I just want you to step back a minute. You answered a number of detailed questions in your witness statement about the fire performance of these panels. And what the questions were really directed at was whether or not you ever gave any real consideration to the effect on the fire event of the fact that the insulation was a combustible polyurethane material. Is the answer that simply wasn't ever the subject of any detailed consideration?
Yeah, I think that is correct. Sorry, just as for instance, you mean if the insulation had instead been some sort of mineral insulation with the same tresper facings? Is that?
Yes. So, for example, did anyone ever consider the likely impact on the fire had the insulating cause been of limited combustibility?
No.
Do you accept that identifying whether the panel was National Class 0 or Class 3 on the 476 Part 7 test was never going to tell you anything about the fire performance of these composite panels as a whole?
No, I don't accept that because the tests were conducted on composite panels as a whole.
Yes, 476 Part 7 tests were conducted
Yeah.
to look at, and they look at surface spread of flame, yes?
Yes.
It's a limited test, yes?
Yes.
Can you help us as to why we don't ever see any suggestion of any other tests being carried out, whether they are standard tests or just bespoke tests to seek to understand in better detail what the fire performance was of these particular panels?
Right, so that was covered in detail by the reconstruction, and indeed I remember some back and forth during the inquest about the peculiar way in which the aluminium frames softened, because the performance of the aluminium was also relevant to the overall external wall construction. And the point was made, I'm sorry, by one of the barristers, one of the QCs, it was about the way that the panel, once it was alight, would start to deform physically as a result of the action of the burning. And the aluminium frame at some point would be incapable of restraining the panel in its original shape, and you start to get the panel pulling away from the frame, which provided a direct route for fire into the building behind. So that was looked at in quite some detail.
I see. But I think we agreed earlier, can we agree this, that the reconstruction didn't seek in any way to look at the phenomenon of downward fire spread, did it?
No, but it did look at how well the panels burnt, how quickly the fire was able to get through them, and, as I said, their mechanical behaviour when undergoing burning.
It was never established, was it, whether the core of the panel was a thermosetting or a thermoplastic insulant, was it?
Well, it was by not specifically as a standalone test, but the fact that the panels charred and formed burning embers means they were thermoplastic. Sorry, they were thermosetting. Wrong word. They were thermosetting, because had they been thermoplastics, they would have melted.
Right, I see. You never did a 476 Part 6 test on the panels, did you?
No, one was proposed, but the once the Part 7 result was in, it was established that the panel could not achieve Class O, and there was a concern raised, I believe, by colleagues in standard testing that there might be a risk to the Part 6 apparatus given how badly the panels had performed. Because the Part 6 is a much more severe exposure than the Part 7 tests. You have both direct flame impingement and some electric heating elements within that furnace.
Right.
And that could have resulted in a severe reaction with these particular products.
Yeah. There was never any bomb calorimetry test done?
No.
There was never any testing under any of the European tests done?
No, because the European test, so particularly the SBI, or the BSEN 13823 test, was deemed a more severe test, and for the criminal investigation we were aiming at the lower end. I should clarify though, your mention of the bomb calorimeter test, we did conduct the cone calorimeter test to try and assess the amount of energy that was produced.
Right. Do you accept that identifying the precise materials and products used and their fire performance in detail would have been hugely beneficial to the industry as a whole in understanding how these panels performed?
You mean if this had been taken further under the fires of special interest report?
Yes.
Yes.
And it would have been hugely beneficial to the industry as a whole, yes?
Yes.
We saw Nick Coop's evidence that you reviewed in your Met Police report that this particular insulation was commonly used in the industry. Do you remember seeing that?
Yes.
So this wasn't a one-off call, was it? It was something you knew was commonly being used, yes?
The polyurethane, yes, but I don't believe its use in combination with the Trespa was common.
What did you base that belief on? How did you know that?
There was something that it was something in the Met's inquiries in terms of the companies that had been manufacturing this stuff. They didn't have a particularly positive view of so Nick Coop of Symphony Windows wasn't manufacturing the panels themselves. They had gone to these other companies and they were listed in the statements. And effectively what I seem to remember being fed back was that they were sort of fly-by-night companies that were set up to just cheaply manufacture these panels for short order processes, and they weren't well-established enterprises in the industry.
So you deduced from that, did you, that these panels were unlikely to be commonly used on other buildings?
Not unlikely per se, but it wasn't apparent to me that they were common or highly common.
Did you ever mention to Brian Martin that it would have been beneficial to industry as a whole to investigate this further?
Well, yes, I wanted the investigation to go on further. I don't think I used to industry as a whole, but yes.
Because we've looked at the objectives of the Real Fires project. Some of those objectives included improving understanding of how unusual fires develop and grow, particularly in domestic and other residential properties, and identify and indicate the need for research arising out of specific problems highlighted in fire investigations, yes?
Yes.
But at no stage was it suggested to Brian Martin that there ought to be further investigations done either on the panels as a composite or on the core?
No, I don't believe it was, but again, they took the decision to shut down the investigation, and we did get to a point later on where we expected things to be fed back to government via the inquest.
Let's have a look at the BRE, the test reports on the sample panels that were done under Part 7, the Part 7 testing. This is at BRE 405878, and I want to look at page 242. So this is from one of the test reports on the the panel, the 476 Part 7 surface spread of flame test reports. And we can see there's some observations underneath the test report. Now, first question, did you ever personally observe these tests, these 476 Part 7 tests?
Yes.
You did. How many of them? All of them or just some of them?
Certainly most of them. Whether or not all of them, I don't know. But
And who would have written these observations up?
the test technician, I had no I was effectively witnessing as the customer,
Yeah.
as far as they were concerned, and everything that's in the report is completed by the test technician.
Yeah. And we can see at line 1, it says incandescent spalling was visible throughout all test runs, yes?
Yes.
And then 3 lines down, specimens were flaming strongly at the end of all test runs, yes?
Yes.
4 lines down, flaming debris was observed burning on the floor for a maximum of 5 seconds each, yeah?
Yes.
Now, just help us with this. We can't see in any of these reports some of the observations you gave earlier about the fact that this material charred. It didn't melt and drip, it charred and then little pieces of char fell off. Where do we find that, either in these test reports or in any other BRE reports?
Apologies, I thought it was in the test reports. If it's not in, well, it may not be in any reports then if it's not in here, but I'm sure I've got photographs of the char and the embers that were formed.
It was sorry.
No, that was it. No.
It was evident from just this standard test, wasn't it, that this was a pretty dangerous combination of materials, yes?
Yes.
Did you ever consider that the combination of these materials and the potential common use of these products might be a topic which ought to be identified to the department as one that ought to be further investigated?
No, because it wasn't. While these may have been common materials, I don't think at the time there was any reason to believe they were being used commonly above 18 metres, where they were non-compliant. They were only being used commonly on buildings which had no restrictions in terms of the use of these materials.
I'm still really struggling to understand what the evidential basis was for that assumption. Can you help us
Well,
with
it's
that?
not an assumption, but an absence of evidence. So, as part of the wider project, there was a watching review, an ongoing review of media articles. External fires, by their very nature, tend to gather a lot of media interest. You get news reports when there really is, cladding systems heavily involved in fire. Those are the kinds of visually impressive incidents that the media get interested in. We would have known if there were lots of other buildings that were also suffering significant fires like this, and that these panels were therefore responsible for that. That simply was not occurring.
I understand you haven't got that information. You haven't got other fires with these particular materials. Although I think, as we established yesterday, you often wouldn't know what the materials were in a fire because the investigation wouldn't get past the summary stage. Agreed?
Agreed, though, where a cladding fire that really does involve the cladding would, by its nature, probably end up being escalated. There is the point about the fires we discussed yesterday that, for whatever reason, the fires didn't get very far and therefore didn't tick those boxes. But had performance of these kinds of panels led to significant story-to-story fire spread, then it probably would have ended up being investigated and followed up.
Isn't the truth of it that there was just a complete absence of evidence about how widespread the use of these panels were?
Well, I don't know, because, again, that's then drifting from investigation of fires to somehow having an overview of all the different construction types that exist within the UK. And that wasn't part of our work, and I don't know how we would have. I mean, maybe there are mechanisms for reviewing all the different types of construction that get put onto buildings in the UK, but that wasn't what we were being asked to do.
wasn't that a recommendation you could have made to Brian Martin? You ought to find out, Mr. Martin, how commonly used these panels are, because what we can tell you is when we tested them to 476 Part 7, it was a disaster. Was that a conversation you ever had with him?
No, but again, this is a... The belief at the time was that, in general, compliance with the regulations and the guidance was being achieved. There wasn't evidence to say that this wasn't being achieved. Lacanau was a very, it was a tragic event, but it was a one-off in terms of what occurred at the time. There wasn't this... there wasn't what resulted from Grenfell in terms of, this realisation that this was occurring as a widespread matter across the UK. And I still think to this day there hasn't been I'm not aware that these materials, these products have been identified as being widespread across buildings in the UK. Not the composite panels that were on Lacanau.
Yes, but can we agree this? You would only know if it was a one-off in terms of what had been used if somebody, I appreciate it might not have been you, but somebody went and looked to find out.
Yes, if you wanted to establish how widespread it was in the UK, you'd need to do a UK-wide survey to find this out.
Well, weren't there organisations that either the BRE or others were in contact with, for example, the CWCT or other such industry organisations, where inquiries could have been made and red flags put up to say, we've tested this panel, it's pretty bad results, even on some limited testing. How commonly used is it? Can anyone give us any information about that? You don't have to do a UK-wide survey to start that investigative trail, do you?
No, true. I certainly wasn't even aware of CWCT at this time, so that would have been for others to do, but I take your point.
I see. Let's look at what you say in your second witness statement on page 28 and paragraph 88H, which is at the very bottom of the page. Now, for context, you'd been providing some information about the emails you sent to Brian Martin in May and June 2010, before that. 2010, about the Fires of Special Interest report. That's in G. And you say this: following this period, I believe that I had very little contact with Brian Martin regarding Lacanau House until the time of the inquest. My general impression was that the view of DCLG at this time, prior to the inquest, was simply that Lacanau had occurred as a result of non-compliance with a previous edition of Approved Document B, the 2000 edition consolidated with 2000 and 2002 amendments, whereas the current edition was the 2006 edition, amended 2007. Matters concerning the adequacy of guidance for firefighting were not within Brian Martin's remit, and I predominantly dealt with Peter Wise in this regard. And then going on in the next subparagraph, little I, you say, note that I was in regular contact with Brian Martin throughout the above period regarding the investigation of Real Fires project generally, but not in respect of Lacanau House in particular. My general impression, as previously stated, was that Lacanau House was not of particular concern to DCLG in terms of potential updates to Approved Document B, given the volume of non-compliances with Approved Document B that had led to its tragic outcome. Now, was that your impression from the 28th of July 2009 onwards, when Brian Martin shut down any further investigation of Lacanau House? Or did you begin to have that impression in terms of the department's view at some later stage?
I think it was around the time of July 2009. Around the summer of 2009.
And looking back at... we can go back a page to what you said in 88H at the bottom of the page. You said, my general impression was that the view of DCLG at this time was simply that Lacanau had occurred as a result of non-compliance. Mm-hmm. From whom specifically did you get that impression?
Brian Martin.
And what specifically did he say to you which led you to form that impression?
probably something very similar to those words, that there was clearly a lot wrong with the building. It was non-compliant in lots of different ways. Therefore, it is not a problem with the guidance as such, it's that people hadn't followed it.
What was your view of the fact that the fire at Lakanal House was not of particular concern to the department? What view did you take at the time you became aware of that?
I suppose I understood the point that was being made. Wasn't necessarily for me to, at that point, I don't know whether I'd have had the confidence to disagree with it. From that point on, I very much turned my focus onto the criminal investigation because, if it isn't the guidance that's the problem, how do I put this? There needed to be something positive drawn out of Lakanal. They had, I wanted, because as with every fatal fire that you attend as an investigator is a personal tragedy. You don't want to see it again. So if the department was of that view in terms of what it might do with the guidance, then for me, and the argument was, well, this occurred as a result of non-compliance. As soon as I was given the opportunity to be involved in the criminal investigation, then I became keen to pursue that and try and do the utmost with it, because if the guidance isn't the problem, then clearly compliance with the guidance is a problem, and you hope that having industry see that there are teeth in the system, that if the guidance isn't followed there will be consequences. You hope that might increase the level of compliance.
Did you get the impression at the time that Mr. Martin was resistant to the idea that there was any problem with the guidance?
I'd say resistance probably a bit strong, but certainly dubious, yes.
Yeah. Did you consider that there were any aspects of the fire at Lakanal House which didn't result simply from non-compliance with the regulations and guidance, but which potentially showed up problems with the regulations and guidance and at least were worthy of further attention from the department?
No, I think all the significant causes of the fire spread, they did ultimately arise from non-compliances, whether with the approved document in time at the 2006-7 refurbishment, or with the guidance that had preceded, because there were earlier refurbishments in the 1980s and 90s, which had impacted on sort of various internal aspects of fire protection in the building also. So I'm just trying to think through in my head all the various forms of defect that existed, because there are quite a few. No, I think everything was covered. There was something that took a bit of uncovering around the 13 layers of paint that were present in the corridors, which isn't directly addressed in approved document B, but I later discovered that there is an approach to testing that's been agreed by the standard testing laboratories called Blue Board, which is around how you assess whether a paint can improve a wall covering to Class O or not. But no, I think all the serious issues did ultimately flow back to non-compliance.
Yes. Can we just look at your third witness statement again, page 54, paragraph 215. You say the composite panels used at Lakanal House were not Class 0. The circumstances at Lakanal House did not indicate there was a widespread issue with cladding on high-rise residential buildings, which has been revealed by the Grenfell Tower Inquiry. Others may take a different view, though I suggest that is with the benefit of hindsight. Now, I think, can we agree that what the circumstances of Lakanal House told you was simply that the external cladding panels were not Class 0, and you wouldn't know whether that was a widespread issue or not without further investigation, yes?
Yes, so that would be repeating our earlier discussion around whether, there was the point about what we knew as a result of fire investigations, and there's a separate point as to what might be known about UK industry at large.
Yeah. Did you ever become aware of any efforts made by the department to establish whether or not the non-compliance of the external cladding panels installed at Lacanau was a situation which had been replicated on other high-rise residential buildings?
I believe there were letters sent to local authorities. Whether they were asking about composite panels or not, I don't know. There was some correspondence, I believe, certainly with London boroughs around blocks of flats at the time.
Right. And that was from the department, was it?
I believe that was from the department.
Right.
But again, at this time, I was, this was very early on in the weeks following the incident, so I wasn't directly involved in those.
Yeah. Can we look at some minutes? If we go to BRE 30043724, these are minutes from a meeting on the 23rd of November 2009, and we can see from page 1 that you are in attendance. You're the fourth name up from the bottom in that list. Do you see that? And this appears to be an LFB meeting about Lacanau House.
Yes.
And if we go on page 2 to the 5th paragraph, beginning discussion. Yes, so it's under the JB2 issues. There's a paragraph beginning discussion, and it says, discussion on whether sufficient information to determine whether this issue was confined to Lacanau or there is a wider public safety issue. Agreed that there is a potential public safety issue. Further information is required, but in view of the potential public safety issue, it must be obtained quickly. And so if we go back up, I think it's clear that they appear to be discussing the panels.
Mm-hmm.
Does that make sense? Do you see that?
Yes.
These composite panels. And you can see that from the very first paragraph underneath the names. Purpose of the meeting is to discuss the panels taken from Lacanau House. BRE were asked to do a full British standard test of the panels. The outcome of those tests led to this meeting. So that's the outcome of the 476 Part 7 tests, yes?
Yes.
So going back over the page to the bit I just read, it does appear that certainly in this LFB meeting, someone's raising the question, do we have sufficient information to determine whether this issue is confined to Lacanau or there's a wider public safety issue? Agreed there is a potential public safety issue. Further information is required, but in view of the potential public safety issue, it must be obtained quickly. Now, can you just help us as to whether you're aware of what happened in response to that minute on the LFB side? Are you aware of that?
I believe there was, again, communication with the London boroughs via LFB. I, again, wasn't directly involved in their activities in that regard.
And was that separate to the letters you just talked about a moment ago from the department?
Yes.
So that didn't involve the department?
Not to my knowledge, no.
Do you know whether any of the steps that were taken after this meeting related to whether or not other high-rise residential buildings had been clad in panels which could not achieve Class 0?
Sorry, could you repeat the
Do
question?
you know whether any of those investigations looked into whether there were other high-rise residential buildings clad in panels which could not achieve Class 0?
I believe that, yes, that's something that became an area of interest for LFB and that they pursued for some time thereafter. Again, I didn't get involved in the detail of that, but yes.
So you told us in your third witness statement that your view was there was no indication of any widespread issue with cladding in high-rise residential buildings, but the LFB appear to be taking a different view in this meeting minute.
Well, they were concerned that it could be an issue, but I don't think. Again, well, it was never reported to me that there ultimately was a widespread issue. I'd like to think I'd have remembered if that had been reported back to me, but I don't recall it ever being said. Actually, having done these checks, there is a widespread problem.
Right. But you don't know what the next steps were or what the outcome was?
No, I wasn't involved in that.
I want to turn now to some more detailed questions about your involvement in the inquest into Lakanal House in 2013. You gave expert evidence to the coroner on various aspects of the fire over the course of 3 days in total, didn't you?
Yes.
You gave evidence initially for 2 days on the 18th and 19th of February 2013, and then you returned for a third day on the 5th of March 2013, after you had provided written answers to the coroner on the 1st of March 2013 to certain questions that she'd asked you to answer, yes?
Yes.
Now, your evidence, which covers 3 full days, was long and very detailed, and I obviously can't go through all of it with you. I want to concentrate with you on some specific parts relating to your evidence about the fire performance of the external panels, yes? Now, before we move on, I just want to look at some correspondence between you and Brian Martin. This is at CLG 100055531.
Yes.
We can see from the top email in the chain, it's dated the 4th of March 2013. So that's the day before you returned to give evidence for your third day at the inquest on the 5th of March 2013, isn't it?
Yes.
Now, we don't need to go through the whole chain, but we can see at the very bottom of page 1 and on to page 2 that the first email is from Brian Martin on the 4th of March 2013. It's just the header to it is right at the bottom, and then this on page 2 is what he says. He says, Dave, in answer to C, you imply that the panel's fire resistance properties contributed to the fire spread from flat 65 to flat 79. Whilst this is no doubt true, it does suggest that compliant panels should have been fire resisting, which isn't true. This only applied to the balcony panels. I know you had to produce this in a hurry, so I thought I'd flag it to you. Do you see that?
Yes.
Now, is that right? Did you have to produce your answers to the coroner's questions in a hurry?
Yes, I think I had to produce them in an evening for the following day.
Right, yeah. Now, your response, if we move up to page 1, to the next email in the chain, it's at the bottom of that page, at 11:31, you say, Hi, Brian. Yes, I'm aware of this, but I was told to assume David Walker's report was correct, ! I think that assertion is on the basis that the same panels were used to cover the external and to separate the escape from the flats. Therefore, it should have done both. Of course, they could have used 2 different panels for each of the areas, but they didn't, Dave. Now, David Walker, he was another expert who gave evidence in the Lakanal inquest, yes?
Yes.
He was a chartered building surveyor and a member of the Royal Institute of Chartered Surveyors, yes?
Yes.
And the chain goes on, this email chain, with Brian Martin at 11:34, on the 4th of March 2013, 11:34, he says, OK, I'm not sure if that's clear in the second para of your SUP report. Does Dave W.'s report say that? And then he's got FR along the length of the balcony. And then he says, are you making it confusing just so they call me, ! I would. And then at the next email up, you say, I think he goes into more detail than that, etc. And then you say, I'm not trying to encourage anyone to call you. Honest, I'll call you later about the report. And he says, OK, yes, I've read it once, thought it was quite good. Yours are better. Do you see that?
Yes.
Now, you were asked about this correspondence and you deal with it at some length in your second witness statement. And if we can go to that at page 29, paragraph 89, you'd been asked there if you called Brian Martin to discuss matters we've just seen, and your answer was probably yes. And then if we go to page 31 of this statement, into paragraph 93, you say in the first few lines there, regarding the contents of my own report to the coroner, I remember at some point having a discussion with Brian Martin concerning the fire resistance of the composite panels at Lakanal House. Mr. Martin was keen to clarify that there was no need for the external walls at Lakanal House to be fire resisting, a point on which he and I were in agreement. My opinion on this point having previously been recorded in section 14.9 of, and then you've set out some exhibits. And you go on, if we look at paragraph 103 on page 33, to explain that your evidence was entirely your own. You say, my evidence was my own, as I was and remain acutely aware of my duties as an expert witness under the various procedure rules. And you were aware of your duties to consider a range of opinions, etc. Yes?
Yes.
Now, my question is this. Why were you discussing the details of your expert evidence to be given to the coroner with Brian Martin at all at this point? How did that come to be?
He asked a question and I answered it. I mean, I didn't alter my evidence as a result of those discussions. As I said, and as I've explained in my statement, my evidence was my own. He expressed a view and I responded.
Yeah.
There wasn't a detailed discussion.
Now, it appears that you had a discussion about this question about whether the panels needed to be fire resisting. Can I summarise it in this way? David Walker, who was one of the other experts, had given evidence in the Lacknell inquest and had perhaps incorrectly indicated that the panels needed to have a fire resistance, like a fire door needs to have a fire resistance, yes?
Yes.
Resistance to the passage of heat and flame through it,
Yes.
And then one of the things that happened is you then had to deal with that, but actually it was Brian Martin that came along and explained to the coroner why the space separation rules in ADB meant that for this building there didn't need to be any fire resistance requirements.
Yes.
Is that an accurate summary in short?
I think so, yes.
Yeah. So you clearly were discussing this question of whether the panels needed to be fire resisting with Brian Martin. Did you discuss any other aspect of your evidence about the external wall?
No, that was the only point he was interested in. He was, as I said, he was keen to make the point that the external walls didn't generally need to be fire resisting because for him, for DCLG, it's a big issue. You know, if the external, and let me explain what I mean by that. If there is a need for the external walls of a building to be fire resisting in totality, that includes the windows. Fire resisting glazing, fire resisting windows are an extremely expensive thing to have. They also mean you can't open your windows because an open window isn't fire resisting. So then there are run-on costs with that in terms of having to air condition buildings because people can't open their windows to manage the temperature. And so the point, and I think it was probably made clear to me at the time, was look, there are lots of implications to this if this stands in the inquest. And I understood that, but my evidence was still my evidence. And I wasn't expressing an opinion in relation to the windows, for instance. That was David Walker that had gone into that sort of territory. My opinion was simply, look, they chose a product, this composite panel, and they decided to put it in all these various locations. And for that one product to have achieved its role in all these various locations, it did need to be both fire resisting and have the relevant reaction to fire properties.
Right, I see. Did Brian Martin say anything else to you? I mean, you said that he was keen to make the point that the external walls didn't generally need to be fire resisting. Was he keen for any other points to be made?
No, that was the only area of concern that he had, I think.
Did you have any discussions around that time about Class Naught? Because your evidence was, well, they weren't Class Naught, they should have been. We'll see in a moment. You say, had they been Class Naught, this is how I would have expected them to perform, yes. Mm-hmm. Did you have any discussions with Brian Martin at this time about the adequacy of Class Naught as a metric for the assessment of fire performance?
No, the focus at that time was simply on establishing what should have been in place for Lacknell and whether or not it was achieved and what the implications were for the deceased.
Yeah. Now, we've seen from the correspondence and we can see you explained to Brian Martin that you had been told to assume that the expert report of David Walker was correct, yes?
Yes.
When you were preparing your answers to the coroner in writing. So you were told to assume that the panels should be fire resisting.
Yes.
As well as anything else about their reaction to fire performance, yes?
Yes.
Let's look at your responses to the coroner's questions. This is at BRE 405886. This is your letter to the coroner dated the 1st of March 2013. And in the second paragraph you write, I've been asked to respond to these questions whilst considering paragraph 329 of David Walker's report. This paragraph states that the composite panel should have been fire resisting to 30 minutes to a height of 1,100 millimetres above floor level along the length of the balcony. In addition, these panels, which were 18 metres or more above ground level, should have had a surface spread of flame performance of class 0. For the internal surface, should have had a spread of flame class 3 as defined in BS 476 Part 7. For the purposes of the questions asked below, I have been asked to assume that the composite panels should have complied with these requirements. For ease of reference, panels which comply with the requirements of the above paragraph shall simply be referred to as compliant panels. So that was the introduction to your letter. I think you've told us just a moment ago, is this right, that you didn't agree with David Walker that the composite panels needed to be fire resisting, certainly those that were in the window sets. Is that right?
Agreed, yes. If there had been specific products for each of those locations, then the ones in the window sets would not have needed to be fire resisting.
Yeah, they only needed to be class 0, according to the guidance in approved document B.
Yes.
Now, even though you've been told to assume that David Walker's correct in his assessment that the panels did need to be fire resisting, can you explain why in this letter you didn't make it clear that you fundamentally disagreed with that these panels only needed to be class 0 and not fire resisting? Why wasn't that something you dealt with at the beginning and said, well, I know you've asked me to assume this, but can I just make clear there isn't a requirement in approved document B for the external wall panels in those window sets to be fire resisting to 30 minutes? Why don't we see that in this letter?
I think I did flag it with counsel to the inquest, and I was instructed to proceed on the basis of this assumption.
I see. Now, if we look at the first question that you're asked, you're asked at A on that, just below the paragraph we read, did the presence of the composite panels in flat 65 have any impact on the fire development within flat 65 beyond the fact that they form part of the material that burned within flat 65? Do you see that?
Yes.
And your answer in the first sentence is, the composite panels in flat 65 burned through. Compliant panels would have taken much longer to burn through. Now, can you help us with this? Was that conclusion based on the assumption that the compliant panels were just class 0, or that compliant panels were both fire resisting to 30 minutes as well as class 0?
Fire resisting and class 0.
Right. And would you have given the same answer if, when you were referring there to compliant panels, you were just referring to them being class 0? So would you have said compliant panels, i.e. those that are class 0, would have taken much longer to burn through? Would that have been your answer at the time?
Probably a similar but different answer. There would have been a qualified answer because class 0 doesn't necessarily prevent a material from failing to provide a barrier to fire spread. But I would have, so the answer would have been that I would have expected compliant, i.e. class 0 panels, to have taken longer to burn through, probably not much longer, as is written in response to these fire resisting and class 0 panels.
So you would have expected them to take longer to burn through, but not much longer?
No. So, in fact, let me explain. Because this, I think, came up in the exchanges in the inquest as well with the interested parties. So even if the panels had been class 0, there was still a point of weakness, if you like, on the external walls in terms of the aluminium frames, which once you get a severe fire and flames coming up from the flat below that's on fire, the aluminium will start to soften and fail to retain the class. Even a non-combustible panel, if it's surrounded by an aluminium frame, will ultimately at some point fail and fire will get through. What I was, and I think I did express several times during the inquest, was what I was interested in was the fact that the panels themselves did ignite, and I believe, their combustibility led to them positively introducing a flame into flat 79, as opposed to mere deformation or the creation of a hole allowing flame from below to get into flat 79.
I see. Well, let's look at some of the transcripts of your evidence in the inquest. I want to go, this is day 34 on the 5th of March 2013, so this is the last occasion you gave evidence after you've provided the letter we looked at. This is to be found at INQ, here we go, 15064. And if we look on page 6, you were being asked by counsel to the inquest about the definitions of various fire performance classifications and other terminology. And if we look at lines 3 to 10, we can see that you're being asked about the definition of class 0 and then about surface spread of flame. So if we look at line 3, it says on the first page of tab 22 at the bottom, we see a definition of class 0, and you answer yes. And then the question is posed, does this relate to surface spread of flame performance? And then you answer yes, it does. And then at line 8, it says, in which case, before going to it in more detail, let's go to page 3 for a definition or explanation of surface spread of flame. Now, it's right, isn't it, that in Lacanau there was a glossary of terms that was prepared?
Yes,
And
that sounds familiar.
I think you can take it from me, we've seen it. And you're being told the definition that we see there is the propensity for a material or product to allow the spread of flame or fire across its surface. Do you see that?
Yes.
And then you say yes. And then the next question, starting at line 14, is this. So bearing that in mind, we then go back to class 0 on page 1. We see that it is a product performance classification for, amongst other things, wall linings. It's the highest national product performance classification for lining materials, and it relates to a concept of limited combustibility. Is that right? And you say yes. Do you see that?
Yes.
Now, looking at that now, and I appreciate we're putting some of these answers under the microscope, I do understand that. That's not correct, is it? Class 0 does not relate to a concept of limited combustibility, does it?
No, I think the point counsel was driving at was there's limited combustibility is referred to within the definition of class 0 in approved document B. But it's the heat of a hearing.
Yes. Well, if we go on to page 7, we can see potentially what the effect of that answer is, because if we go to line 13 in this, he's going through the glossary. You can see the glossary being referred to at line 9. And then if we look at line 13, he says, then above that, limited combustibility, capable of burning but not liable to burn unless under an imposed heat source. Do you see that? So counsel is pointing out what the definition of limited combustibility is. And you say, yes, that's correct. And then at 17, the question is, so when we're thinking about something with characteristics of class 0, we are talking about something which is capable of burning but is not liable to burn unless under an imposed heat source. And we are looking at its ability to allow or prevent the spread of flame or fire across its surface. Is that right? And you say, yes, that's correct. And then you go on and you say, can I just elaborate briefly? Please do. And then you say, answer, in the context of a composite product, it is possible, and then you go over the page, that you might have a combustible component to that product somewhere within a number of layers. The tests for class 0 relate specifically to the surface. And then you say this, so the surface should be of limited combustibility, and there are test criteria that they use to determine that. But it is possible that you might have a combustible layer somewhere within that product, but that it is protected to a sufficient extent by that layer that's of limited combustibility, or that surface that's of limited combustibility. Do you see that?
Yes.
Now, if we go back to line 17 on the page before, we can see that having read out the definition of limited combustibility, council is conflating the characteristics of what are class naught with the definition of limited combustibility in his question to you. Do you see that?
Yes, I see that.
Can you help me understand this? I'm just looking at lines 18 to 20, in which council seems to be suggesting that a material of limited combustibility is one that is capable of burning but not liable to burn unless under an imposed heat source. What does that mean?
So, and this is where similarities get drawn between Class O and limited combustibility. In practice, when you're say you're running experiments and you've got materials that achieve either of these, if you say apply a blow lamp to the surface of that material, then you will see not just the blow lamp flame, but there are flames that are arising off of the surface. But the moment you take that blow lamp away, the surface will invariably self-extinguish.
You mean a continuously imposed heat source?
Yes. Yes.
Because the words used here suggest it could apply to a piece of paper.
Yes, I understand. Yes, yeah. No, but I think what is meant is a continuously imposed heat
All
source.
right, no,
Yes.
that makes better sense. Thank you very much.
But you see, at 17, council says, so when we are thinking about something with characteristics of class naught, we are talking about something which is capable of burning but is not liable to burn unless under an imposed heat source. Do you see that?
Yes.
Now, that's not right, is it? He's conflated class naught with the definition above of limited combustibility.
He has somewhat, but there was this point about the glossary was trying to make things as readily understandable as possible for the jury about the various performances, and the key point that I think council was keen to get across was that we have this category of materials that are not non-combustible, but that will only burn under particularly severe conditions. And from the moment those conditions are taken away, i.e. a fire is extinguished or whatever, they're not going to continue burning under their own steam.
I see. And is that how you understood a class naught material to perform invariably at that time?
No, not invariably, but again, this was, there's the full complexity of issues as you understand them as an expert. And, if I were discussing this with a fellow fire safety expert or a fire scientist, there's one form of language that I would use. But when you're trying to convey these concepts to a lay jury, you try and work out ways of making sure they understand the key concepts sufficiently to enable them to reach a conclusion. And this was, not just myself, this was in consultation with council, how best to try and convey these concepts.
Wasn't it crucial to make clear to the jury that class naught and limited combustibility were not the same? They're very different, aren't they?
Not in the context of Lacanau, because the difference between the two didn't arise. In terms of whether or not Lacanau was compliant, I don't think there was any aspect to the building which would have been compliant in terms of one but not the other.
Well, we'll see that you are asked to address the question, what difference would a class naught material have made? We'll come on to that in your evidence. In those circumstances, isn't it important that you're very clear what the difference is between a class naught material in terms of its fire performance and a limited combustibility material?
Not in the context of those answers, because again, this goes back to the earlier point that I made, which is, there's the fundamental separation between fire resistance on the one hand, the ability of something to provide a barrier to fire and to remain a continuous barrier to fire for a length of time, versus whether or not something burns. And the point what the issue turned on with Lacanau was, on the one hand, these panels were combustible and were therefore capable of introducing a flame inside the flats even though the fire was external in nature and was therefore able to ignite things. And then on the other hand, there was the point that the external walls opened up. The openings would form in them at some point during the incident, and whether or not they were burning, flame, i.e. the external fire plume, would enter the flat and would ignite things, typically the curtains that were nearest the window. And so the distinction and the various debates that were surrounding Lacanau were around the difference between fire resistance and reaction to fire, but there wasn't a debate about whether limited combustibility or Class O would have made a substantial difference.
Yes, but thinking about the coroner's wider duty to make recommendations, wouldn't it be quite important for the coroner to understand how a Class 0 material would perform, and to understand clearly that it would perform differently from a material of limited combustibility?
I don't think it would have performed differently. So again, this goes back to the earlier point, and it was the point raised by, I think will come back to me at some point, one of the QCs. As soon as the aluminium frame, so in terms of fire resistance, the aluminium frame is one of the key weaknesses, that you can get distortion of the panels and they start to pull away from the building, and from that moment on, the fire plume can get into the flats and ignite the contents. That same mechanism would have been true if the panels had limited combustibility components but were still only formed of materials that would not retain their rigidity under a fire attack, because limited combustibility does not lead to a material suddenly being rigid in the face of fire attack. It just means it doesn't release a great deal of energy. It doesn't, cause the barrel furnace that's used for the test to increase in temperature by more than 25, 35 degrees. But that does nothing for the mechanical properties. It doesn't lead directly to a change in the mechanical properties of the wall.
Right. Let's go back over the page again to look at page 8 and lines 2 to 4 of your answer. You say the tests for Class 0 relate specifically to the surface. Fine. And then you say, so the surface should be of limited combustibility, and there are test criteria that they use to determine that. Now, again, that's wholly incorrect, isn't it?
Yeah, that's a mistake. Simply,
the surface might be of limited combustibility. That might be one route to satisfying Class 0. But if you've gone via the 476 Part 6 and Part 7 tests, that surface might not be of limited combustibility, yes?
Agreed.
So the problem here with your answer is that although you are just drawing a distinction between the performance of the core and the performance of the surface, you're implying that the surface will be of limited combustibility, and that really might not be the case. Can we agree?
Yes,
there?
no. I think there's a mistake in there. It was using the way that it's defined in approved document B. I was trying to illustrate that the concept that you might well have a composite material which has readily combustible layers within it, but that they are protected by something on the outside, and yet, as in spite of that combustibility within, you will still achieve Class 0.
Yes, but they might not be protected. That's part of the problem with Class 0, isn't it?
Yes.
Now, if we go on to page 11 in this transcript and to line 5, you're asked another question. So, if the composite panels in place had been Class 0, what effect, in your opinion, would that have had on whether, and if so, when they would have ignited? So you are asked that question directly. What difference is Class 0 going to make here? And you say this. You say, if the panels had been Class 0, then I would have expected them maybe to char or blister to a limited extent under the effect of the flames from flat 65. I would not have expected them to ignite and burn in their own right. So if flaming ceased or was even intermittent from flat 65, I would not have expected sustained flaming at those panels. Now, do you accept that the whole of your answer there appears to be based on the wholly false assumption that Class 0 meant something that was of limited combustibility, or even that it was non-combustible, the way you've expressed it there?
No, I don't accept that.
It's simply not correct to state, is it, that products which are class 0 would char or blister to a limited extent, but would not ignite and burn in their own right?
I think it is correct to say that, because that is the outcome of the Part 7 and Part 6 tests, is that had these panels been class 0, then even under the imposed heat flux from the Part 7 test, which peaks at the numbers are given in the exhibits to my statement. There's a graph that sets them out, but there's a very high heat flux, I think above 50 kilowatts per square metre, nearest the radiant panel on the Part 7 test. And the point is that the test specimen cannot undergo flame spread of more than, I think, 65 millimetres during the course of the test, in spite of that extreme heat flux. So given the amount of heat flux you might actually get from the flaming that's emitting from below, I would not expect a great deal of self-sustained flaming from the panels. There remains the point about fire resistance and whether the panels would fall away, but had the panels been Class O, then I wouldn't have expected them to cause a great deal of flaming in their own right.
I see. So that was your understanding, was it, of the effect of passing the 476 and Part 7 tests in terms of fire performance, yes?
Yes.
And did you ever check that understanding with any of your colleagues at the BRE?
Well, it would have been explained to me. I mean, I wasn't born with that knowledge. At some point, I will have had input from someone about Part 6 and Part 7.
Did you ever ask Sarah Colwell whether it's right that a Class 0 product can be expected to char or blister to a limited extent on the effect of flames, but would not be expected to ignite and burn in their own right?
I don't think that's a conversation I ever had with Sarah Colwell.
Or with Dr. Debbie Smith? Did you ever ask her that question?
I don't recall asking her that question. It's not impossible. I may have done, but I don't recall a question like that.
Because one of the difficulties with this is that you don't appear in this answer, or indeed in any other, to take account of the combustibility of the core of the product in terms of the likely fire performance of the panel, even if it had achieved Class 0.
Right, I understand the point. Not directly, no, because I wasn't asked that specific question, but there was a question at some other point during the inquest around the exposure of the edges of the panels and the fact that the underlying insulation, I think that there is flaming that occurs once the foam core is exposed during the course of the reconstruction, which was discussed during the inquest. And that same phenomenon, I agree, could have occurred in the case of a Class O panel.
Yeah. Let's look at page 20, please, and your answer at line 18 onwards. So the coroner, let's pick it up at 11. The coroner says, it's a lot to take in. I wonder if you could perhaps, in just a couple of sentences, give us a summary answer. You've helpfully given us the background to it, and I appreciate it's a more complicated answer than you would perhaps want to summarise. But I think it would be helpful if you could just summarise it in a couple of sentences. And you say, OK, at its simplest, a composite panel that was Class 0 but was not fire resisting, I would not expect it to have ignited and sustained flaming in the way that the composite panels did. But it would be entirely reasonable for that panel not to be expected to provide a barrier to fire spread from one side to the other. And that relates back quite nicely to the glossary, actually, in that it shouldn't have burnt if it was Class 0, but it wouldn't necessarily maintain that barrier across the window facade. Now, that phrase, it shouldn't have burnt if it was Class 0, looking at that now, can you see how that might have been misleading, given actually what Class 0 tests a product for?
To a point, it goes back to this. I mean, I was attempting to summarise an awful lot, but it goes back to this point about whether there's an imposed heat flux or not. And yeah, I mean, I take the point regarding the foam core, although that had been discussed, but I was attempting to summarise a lot in a very short number of words.
Yes. You make a similar statement about National Class Naught in your report to the police. That was the report we looked at earlier. If we could go to BRE 405881 at page 18. Now here, admittedly, you're dealing with the corridor walls, but you're nevertheless looking at the National Class Naught recommendation. And we can see that 3 paragraphs down, under that heading, Corridor Walls Reaction to Fire, you say this: the Class Naught recommendation effectively means that walls in common and circulation spaces should be of very limited combustibility. Now, pause there. You're mixing up Class Naught and limited combustibility, aren't you, in this report?
Yeah, it's a poor choice of words. I don't think I'm that's very limited combustibility is an odd thing to say in hindsight. I don't think I meant to conflate the two, but I can see it's a poor choice of words.
And then you say, a Class Naught surface, in my opinion, would not have contributed to the spread of the fire. It may burn, but it would not be expected to contribute to the size and spread of the fire. Do you see that there?
Yes.
Now, again, do you stand by that now? Would you say that now about Class Naught?
In the context of the walls to this corridor, yes, I would stand by that.
Why is it any different? You're describing, I appreciate you're talking about a different location, but it's nevertheless the Class Naught test. Why are you describing a Class Naught material as one which may burn, but it would not be expected to contribute to the size and spread of the fire? In my opinion, the surfaces of the walls of the common corridors did contribute to the spread of the fire, etc.
Because it goes back to the point about the expectation that Class Naught will self-extinguish once you take away the heat source. And the corridor, these were concrete or blockwork corridors, and layers of paint that had been applied to them. And had there been a Class Naught paint or a number of layers of Class Naught paint applied, then I wouldn't have expected them to contribute significantly to the fire. They would have burned to where they were under direct flame impingement from the fire emitting from flat 79, but I wouldn't have expected the entire corridor to become engulfed in the way that it did.
I see. Mr. Chairman, would that be a good moment for our lunch break? I know it's a couple of minutes early, but we're doing okay for time.
That's all right. Yes, I think it would be a good point. Dr. Crowder, we'll stop there so we can all have some lunch. We'll resume, please, at 2:00. And please don't talk to anyone about your evidence while you're out of the room.
Of course.
All right. Thank you very much.
Thank you.
Thank you very much. 2:00, please.
Thank you.